Hi, I'm Philippa McDonald, and welcome to a special series of interviews brought to you by Compass on enduring powers of attorney. Robert Fitzgerald, how can enduring powers of attorney be abused?
Well, I think it's a really tricky area, Philippa, because it's an area where, in fact, the older person has appointed someone whom they trust. And at the end of the day, that trust is being breached when we see abuse, financial abuse, under a power of attorney. So we've seen in the work of the Age Discrimination Commissioner and other adult safeguarding units around Australia, lots and an increasing number of examples of abuse. So just a couple. There was a son who, in fact, exercised a power of attorney on behalf of his mother. He stole $117,000 from her bank accounts, another $50,000 through the ATMs to feed his gambling habit. And that was an example where, in a sense, he had a problem, which was his problem gambling, but he accessed the power of attorney and then accessed all the financial accounts. So that's an example of where getting access to the financial accounts is one. Another case was a daughter in relation to an old couple, an elderly couple. And in fact, she was also appointed as an attorney. She stopped spending money on her parents, and so they went into neglect, very, very substantial neglect, the withdrawal of services into the home, and ultimately that leads to ill health hospitalisation. Once that matter came to the Commission, we discovered that she had taken $900,000 and put it into her own accounts. So powers of attorney can be abused by the very people you trust, but because they have that instrument, in fact, they do get access to bank accounts and other sort of financial institutions. And that's a growing problem within the Australian environment.
Well, you say it's a growing problem, but what recourse is there if someone steals essentially $900,000 from their parents?
So the difficulty with it is people react too late. So if you've given someone a power of attorney and you start to see things occurring which are inappropriate, which you don't agree with, which you didn't sanction, if you start to see money going out which you hadn't authorised, and let's assume you've got full capacity, then in fact that's the time to act then. But if it does go to the point where somebody, in fact, has stolen the money, in Australia, there's only a couple of ways you can get that back. One is through going to court in New South Wales, that's the Supreme Court of New South Wales, and similarly in other jurisdictions. Or in Victoria, there are circumstances where you can go through the VCAT, and that tribunal is a much more I think, effective means of achieving redress. But beyond that, it's almost impossible, other than through the goodwill of the person who's stolen the money. And often it's gone, and in the case of gambling, it's definitely gone.
You're saying that this problem, this form of elder abuse through enduring powers of attorney is growing?
Yes, there's no question about that at all. So abuse of older people is growing generally. And the reason for that is there's more older people, but more older people in the risk category. And that is about 70, 75 years of age, three things happen to us. The first is we become frailer. The second is we become more dependent. And the third for some of us is we start to lose some of our cognitive abilities. Not fully, but over time. Those three risk factors are ever present, and there's simply more older people in that. The second thing in relation to financial abuse is our children have to wait much, much longer to get the inheritance. So by the time, my children will receive the inheritance, they might well be into their 50s, 60s, even 70s. And so that impatience that's growing in the younger generation, the adult children, is in fact a driver of some of this abuse as well. And the third factor is that younger people in financial stress will look at ways to mitigate that, and some of them look to their parents, not only to get assistance, but actually to take money from them on the belief that at some stage they'll get it anyway, so why shouldn't I have it now? But there's no doubt at all that elder abuse will increase in terms of numbers, not necessarily in terms of prevalence rates.
Well, Compass.info hears stories of people who have used enduring powers of attorney to steal money and assets from older people.
Sure.
How can you protect yourself?
Well, a couple of things about this. The first thing is we would encourage people to get an enduring power of attorney. It's a very important instrument. And for most of us, we'll choose well. The people we trust will do the right thing by us. But the really big challenge is firstly to understand what you're doing when you're giving a power of attorney to somebody else. Do you actually know what that means? Do you know when that the attorney can actually start exercising that power of attorney? Do you actually believe that you can do something, take control when you see things happening that you don't approve of? And that happens quite small. Small little things start to occur. The fourth thing is, if you really are concerned, not only seek advice, but revoke the power of attorney. Just stop it. And most people that we've dealt with in adult safeguarding units, including the Age and Disability Commission, but across the nation, they don't even realise they can revoke the power of attorney. So there are a number of things you can do. But the most important thing is choose well. But very importantly, if you're starting to be concerned at all, talk to the attorney, start to in fact rein it in a little bit, or seek advice and ultimately revoke. Now beyond that, there's not a lot you can do once you've given that attorney.
So act early, but also to revoke an enduring power of attorney.
Yes.
How difficult is that?
It's different in every state and territory. One of the things that I'll be trying to work on is getting some harmonisation. So firstly, it's easier. There should be a standard form that you fill out. There should be a standard set of instructions as to what you do with that form. You should be able to inform the power of attorney directly, but even irrespective of that, the minute you revoke it, those powers should cease. So there's a number of things that the system itself needs to change to make it much clearer, much easier, much more effective to revoke. The problem at the moment in some states and territories is you can revoke a power of attorney. The actual attorney, the person that you've appointed, doesn't know. They continue to use or misuse the funds. Institutions don't know that you've revoked it. So at the moment, it's a bit of a mess. And what we've got to do as a nation across the 9 governments is to fix that. And I think that's relatively easy to fix within a short period of time.
So will that be one of the priority areas for you as Australia's new Age Discrimination Commissioner?
Well, elder abuse is absolutely one of the core streams of activities that I'll be paying attention to. And that's about making it more easily understood by all parties. The person that's giving the power, the actual attorney themselves, making sure that if you want to revoke, it's easier, clearer and much more effective than the current regime. But most importantly, it's about educating everybody about these powers of attorneys, what they're about, what are the powers, how far you can go, how far you can't go, and then at the end of the day, to change it or revoke it if that's possible. Because right at the moment, a lot of the abuse we see around Australia, it didn't start off as being deliberate. It's been this creeping. People don't know the boundaries. They start to do things which in their own mind they justify, but very soon it grows. So you see people, taking small amounts of money to compensate them for time or effort or energy. Then you see they start to buy a car for themselves so that they can take their mother or sister or brother or father to the medical centre. But that might only happen, once every 2 weeks or once every month. Then the third thing they start to do is they start to spend money on their own house and their own, needs and desires. So often it's really a misunderstanding of the boundaries, but it certainly grows into abuse over a period of time.
So if you're an older person and you think it is abusive and it might still just be the early stages, who can you turn to?
So a couple of things about that. The first thing is you shouldn't hesitate to ring the National Elder Abuse Helpline. Ringing that line doesn't mean you're making a report about your son and daughter. It's about seeking information. And that call will be referred to each state and territory where you are. In South Australia, it's their Adult Safeguarding Unit. In Canberra, it's through the Human Rights Commission, which also has an Adult Safeguarding. New South Wales, Ageing and Disability. So that's one place. The second is to talk to your advisors, your lawyers, your accountant, other people you seek guidance from. And just so you're concerned, many of those will be able to direct you in the right place. And lastly, of course, you can seek legal advice either through legal aid. The guardian and trustees are very good about this, or your own lawyers. So I think there's lots of advice, but the key is when you become concerned, ring, contact somebody just to have a discussion to see whether or not your concerns are legitimate or not.
When you talk about leaving it too late, what kind of time period could you be thinking about?
Very early. If you're starting to see somebody taking over decisions on your behalf and you don't want them to, that's a clear sign. It's a bit like coercive control in domestic and family violence. If you start to see them exercising the powers under the power of attorney well before you thought they should, that's a clear sign. that's happening. If you're starting to lose capacity, mental capacity, and you know that, it takes time for that to happen, and you're worried that this person is no longer the trusted person you thought of 10 years ago, then start to act now. If you wait, you'll get trapped. You'll get trapped into a snare of their own influence, the control they take over you. And abusers are very, very good at taking control of your lives. We know that in domestic and family violence, called coercive conduct or control, and we see the same in elder abuse.
This is no different.
It's only different necessarily between the relationships. Most of coercive control is around intimate partners, spouses, partners. In this case, it can be your own adult children. And so it's really just different in who's doing it and the nature of the circumstances. But behind most abuse is what's called psychological abuse. That rates very highly. In the prevalence study that was done a couple of years, 15% of older Australians identified as having been abused. The largest group identified psychological abuse as being the key. But that sits behind financial abuse, it often sits behind physical abuse, it sits behind exploitation, and tragically, it also sits behind neglect, where people take control and stop you accessing the services which you both need and you would otherwise acquire.
Give us an example of that.
Well, one of the big problems that happened during the pandemic was what we call medical neglect. And what occurred there is families moved in with older people. They didn't want the older person spending money. They stopped home services coming in. They stopped the person going out and accessing medical services, dental services, allied health services, social supports. So the person became isolated in their home, needing more and more care but getting less and less of it. And what was happening is they simply didn't want their mother to spend the money or their father. And they would say, oh, you really don't need a new dress. You really don't need to see the podiatrist. And that's actually got a name. It's called inheritance maintenance. But it became really problematic during the pandemic and it persists today. And medical neglect is a really big problem where older people and some people with disability have not been receiving the care that they deserve because others won't let them spend, a co-payment or whatever it might be. So it's quite a significant issue. And neglect can often be people that have exercised psychological abuse, taken control, and it can be a part of financial abuse as well.
Well, is it better to have multiple attorneys who can act for you jointly?
Well, that depends on whether you like your brothers and sisters and everybody else. Look, it's a really difficult thing. For simplicity, it's easier to have one person. The problem is if it's only one person and you're fairly isolated, that can be a risk. If you have two or more, then it complicates it because it's generally joint decision making. And so there's a trade-off. Do you want more safety by having, 2 or 3 people, or do you want to have it easier for the attorney to be able to exercise it? So the answer to that question is completely circumstantial as to your own, environment. But I do think increasingly a couple of people as joint attorneys is reasonable and workable. Any more than that's pretty difficult. The second thing is, irrespective of who you appoint as attorney, make sure other people know. Make sure other people know that you've actually provided a power of attorney to John or to Mary or whoever it might be, and make sure that that you talk to them about any concerns you have as well. The big danger is where you appoint one attorney, nobody else knows, you're fairly isolated in the way I've described. That's high danger.
How prescriptive should you be in an enduring power of attorney about your financial wishes, your health wishes, and your other wishes to have it set in black and white?
So you shouldn't have to do that if the attorney is being exercised appropriately. But I think increasingly what we'll see, especially if it's being prepared by a lawyer, you will start to see a greater clarification of what the role and function of that attorney could be. In other words, what are the boundaries? But the truth of the matter is that should not be necessary. If we can actually start to educate both the person giving the power and the attorney in their responsibility, and there are other eyes looking at that relationship. But increasingly, I think powers of attorney will have more and more prescription. But my view is that's an unfortunate phenomenon because it'll just make things more complex.
Well, then let's look at what you would say should be in your toolkit to make an enduring power of attorney safer.
So the first thing to be very clear is, do you want to enter into it, and why do you want to enter into it? So not everybody has them, but at some stage they become very important because the power exists even when you lose capacity, which will happen to many of us over time. The second thing is to be very clear that you understand what you're doing with that power of attorney. And that means asking and asking and asking the advisors that have prepared that document for you. Do not hesitate to ask silly questions. It's very important. Third thing is you really do have to do a check on the person you're giving the attorney to. Is this person that is likely to do the right thing by you? So a couple of telltale signs. You should never give a power of attorney to someone that has a problem with gambling. It is a surefire way of having abuse happen to you. The problem gambler, when they've got a severe problem, a severe addiction, will not stop gambling until they run out of money, and that includes your money. So that's a telltale sign. You would not appoint somebody that's had financial difficulties, bankruptcy in the last, sort of 5 or so years. You just would not do that. And you certainly wouldn't do that with somebody that's already doing it tough. A lot of our children are in debt. A lot of our children, require assistance. That is not a good person to appoint at that point in time. So what you want to do is to pick someone that doesn't have those obvious vulnerabilities. And then the last one is to make sure that you know what's happening on an ongoing basis. But the moment you start to see something go wrong, either discuss it with the attorney or somebody else. But these move over time, and the difficulty with powers of attorney, you do it today and it's still valid 10 or 15 years from now. And so the problem with the power of attorney is it's not just how you are feeling about that person today, it's how you feel about them 5 years, 10 years, 15, and it may have changed. Those issues that I've talked about may not have been present when you appointed somebody, but they might be well present 15 years' time. If you don't change it, you run that risk. And that's the problem. It is a document that lasts a long time. It's not like, what do you think of the person today, and it's about today's transaction. This will happen over a long time. And people are very reluctant to say to somebody, I don't want you to be my attorney anymore. And if the person's resistant to it, even more so. And even more so if it's your son or daughter.
You've given us some of the nightmare situations that have happened to some people that have come to you, and the remedies for financial abuse seem to be thin on the ground.
They're very hard to access. Either the money's gone, and the son or daughter or whomever the person is that's been abusing you may not have any assets. The second thing is the only way you can reclaim it in most jurisdictions is through the Supreme Court, for example. That is very difficult, very lengthy, and you may or may not recover. The third part of it, I think, is that often you don't have any means yourself. You've just lost it. So unless legal aid is prepared to come to the rescue, and that varies in different states and territories, it's going to be very difficult for you to access it. Good news is the banks are much more proactive. The banks themselves are starting to take action against people that misused a power of attorney and then misused bank accounts. So the banking industry is becoming much more proactive. And it is possible that other financial means of redress might emerge. But my own view is that we need to find easier and better ways for financial redress. And the other one is we think that people that abuse powers of attorney probably should, based on some threshold of severity, some face criminal prosecutions as well.
Tell us what criminal sanctions could look like.
So at the moment you have to use all of the normal Crime Act areas of fraud to in fact have a criminal prosecution. And people are very, very, very loath to call in the police in relation to these matters, especially if it's a relative. But in some circumstances the abuse is so grievous, so wrong, so intentional that in fact that's what we should have. So my view is the conversation we should be having nationally across Australia is whether or not there should be a specific criminal law where you intentionally breach your fiduciary duties, as it's called, your duties of care, under that power of attorney. And I think there's a very good case for looking at that. And I think that's something that should happen. So firstly, how do we fix the ability to get financial restitution? The second is, I think, some criminal penalty around powers of attorney, enduring powers of attorney in particular, is probably warranted. but there's a bit more work to be done, and there's a lot of work being done by various law reform commissions and other bodies around Australia in relation to powers of attorney. But I'd be very surprised if there isn't a push for some criminal penalty associated with powers of attorney.
In your role as Age Discrimination Commissioner, will you be advocating for criminal penalties for those people who do seriously abuse enduring powers of attorney?
Well, I think the conversation is already being had. I'd like to see the research that's being developed in various jurisdictions, and then subject to proper consultation. I think it is worthy of consideration, and my own personal view is I think it is inevitable that something like that will be necessary. The issue is that the criminal laws are different in every state. So there might be states where it's actually whatever they've got at the moment is really effective. Our advice is that the laws are difficult to apply, and police are reluctant to apply them, and as a consequence, a simpler, clearer law in relation to this, I think, might be beneficial to the police, to prosecutors, and to the community at large. But Philippa, most importantly, it'll send a message. A lot of laws are not about whether they get used a lot. It's whether they send a clear message. And the message we've got to send is that if you are an attorney appointed by an older person or a person with disability, then you have very clear obligations. And if you breach those obligations, there is a penalty. Now, the point that I make is it doesn't always start off intentionally to do the wrong thing. But at some point it does. And at some point the attorney knows exactly what he or she is doing. And when you've got that intent, I think there should be penalties. Because I think the current arrangements are just too difficult for the police, for prosecutors, and ultimately it's not sending the right message.
There's not enough of a deterrent.
It's so rarely used, it's so hard to use, that I think, yes, you're absolutely right, it's not a deterrent. When you say something as specific as if subject to the thresholds I talked about of severity, if you breach that fiduciary duty in an intentional way and to a significant degree, you can face a criminal penalty. It sends a very, very different message than what we've got out there at the moment.
If you go to jail.
Well, yeah, criminal penalties generally have, graduating penalties, but yeah, jail could be the case. Would that happen very often? Not a lot. Do most fraud cases end up in jail? Not a lot. But we don't get rid of the fraud laws because of that. I think in this case, when people know that there is a penalty for doing the wrong thing, it will send a signal. It'll also send a signal to the law, to lawyers and advisors generally, who have to do a much, much, much better job in educating their client and educating the person who's receiving the attorney. And one of the things I think should be the case is the attorney should be required to sign an undertaking when accepting that position. At the moment, you get appointed. You don't even know you've been appointed. You don't have to get any advice. You don't sign anything. So, you wander off and at some stage decide you're going to act as an attorney. My view is that at the point where the attorney accepts that position, they should be required to sign some document. And I think that would help as well. But at that time, they would then be advised of the penalties for failing to act. What we don't want to do is discourage people from being attorneys. So, this is the danger. Every time you introduce a law, there's a perverse effect. So that's why I keep saying about thresholds. If we get it right, it's a deterrent, but it doesn't stop people wanting to be attorneys. If you get it wrong, then in fact there is that danger. So the answer is yes, I think we're going down that path. We've just got to make sure we get it right.
Thank you very much, Robert Fitzgerald.
Good, thanks, Philippa.
Thank you.